Every day in the USA, people find themselves in court.
Can I have your name, please?
I'll say Brink.
All right, Ms. Brink, we'll call your case. This is the state of Michigan versus Chelsea Brink, file 25-44051-FY. Today is the date and time set for a felony status review. Mr. Brown, I believe this is your case. Is that correct?
That is correct, Judge.
Do we have a resolution of this matter?
I believe we actually do. I was speaking with Mr. Fortier. He has made a plea offer, which is essentially to plead to the retail fraud as charged. There are 2 felony counts of R&O. There is an offer to plead to 2 counts of attempted R&O. I did discuss that with Ms. Brink, and I believe she is going to take that offer.
All right, Mr. Fortier, I believe attempted resisting and obstructing would be a 1 year and or a $1,000 misdemeanor offense. Is that correct?
Correct.
All right. So Ms. Brink, as I understand it, the 2 assault or resisting and obstructing police officer offenses, which are felony offenses, would be reduced down to misdemeanor offenses. And then you would also be asked to plead to the retail fraud misdemeanor. And in exchange, the felony offenses for resisting and obstructing police would be dismissed, as well as the habitual offender would be dismissed. Is that your understanding of the agreement as well?
Yes, sir.
And is that what you want to do?
Yes, sir.
Have you had an adequate opportunity to speak with your lawyer about that?
Yes, sir.
All right. If you want to do that, you would be giving up your right to have a trial and all of the rights that you would have at trial. So let me inform you of those so you can make an informed decision. At a trial, you'd have the right to have a lawyer represent you. You'd have the right to see, hear, and question all the witnesses against you. You'd have the right to present your own evidence and your own witnesses and get an order from the court requiring them to testify. You could also testify yourself, or you could remain silent. And if you chose to remain silent, that silence could not be used against you. At a trial, you'd also have the right to be presumed innocent until proven guilty beyond a reasonable doubt. And that burden of proof would remain with the prosecutor at all times. Finally, at a trial, you'd have the right to automatically appeal any error at that trial. However, if you enter a plea, you'd be limited to asking the court for permission to appeal. Do you understand all of those rights?
Yes, sir.
Do you have any questions about any of those rights?
No, sir.
Knowing all of those rights, is it still your intent to enter your plea today?
Yes, sir.
All right, I'm going to have to take some testimony from you. So would you raise your right hand, please? You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, go ahead and put your hand down. Other than this plea agreement that we've talked about today, has anybody promised you anything to get you to plead today?
No, sir.
Has anybody threatened you in any way to get you to plead today?
No, sir.
Are you doing this of your own free choice and free will?
Yes, sir.
All right, let me start with the police officer charges. The new or amended charges would be attempted resisting and obstructing, a 1-year misdemeanor. And they would say that on or about September 21st of 2025 in the city of Gaylord and Otsego County, that you did attempt to assault, batter, wound, resist, or obstruct, or oppose, or endanger Officer Daniel Gertz and Officer Jacob Depew, police officers who you knew were performing their duties. Is that what you did?
Yes, sir.
Can you tell me what you did to those officers that was resisting and obstructing them?
I just didn't turn around when he asked me to, the first time he asked me to, and kind of I ran my mouth to him.
Well, typically, attempted resisting and obstructing has to do something more than just talking. It's got to be some physical activity or some action that you took that either resisted them.
Right, that's what I'm saying. I didn't turn around.
Okay. Did you take some physical action either towards the officers or with the officers?
No.
Mr. Brown, is there any questions that you want to ask at this point?
Yes, Your Honor. Chelsea, do you remember being at the Walmart when the police showed up?
Yeah,
And you were there because I believe Walmart had called because of a potential theft, right?
right.
And when the police were they asking you to do certain things, giving you commands?
But he just said, after he questioned me about what happened, I have mental health problems, so I get sick sometimes, and I wasn't quite understanding what was going on. But anyways, he said that I was going to be arrested, and Depew asked me to turn around, and I said, I dare you. And so, like
So
an
when they
idiot, he came at me and grabbed me by the arm, and I didn't move from where I was standing. I didn't assault him or anything like that. I just didn't help him arrest me. I
did
mean,
you kind of
it's hard for me to agree to something so
did you tense up while they
negative
were trying
that
to?
I'm not going to, I probably will always resist because I don't agree with some of the laws.
Well,
So,
Ms. Brink, they gave you a command. You did not immediately comply with that. When they were
right.
trying to arrest you, did you kind of resist by tensing your arms up so they could not do that?
Yes. Yeah.
Thank you.
And you did that
Were
with
they in
both of
full
the officers?
uniform? You knew they were officers, correct?
Yes, I did. Yeah.
Okay, thank you.
All right. Any other factual basis questions that you have, Mr. Fortier?
No, Judge.
All right. As to count one and count two, I do find that she's given me a proper factual basis. She's resisted the lawful arrest and the commands for the arrest by the police officers at Walmart in Otsego County on or about September 21st. Ms. Brink, as to count three, which is the retail fraud, that reads that on or about September 21st of 2025, that you were in the Walmart store, which was open to the public, and you stole property of the store that was offered for sale at a price over $200, but less than $1,000. What did you do there?
By the time I got to the door, actually, let me back up. I went in to use the bathroom, to be honest with you. Actually, let me back up even further. I drank a beer and I relapsed. And
Well,
the day before, I spent the whole day.
Chelsea, I think what he's asking you is, did you take anything? I don't necessarily know if he needs the entire story. Did you take anything?
Yes, I did take
Yeah.
stuff. It was a baby seat and
Ms. Brink, hang on a second. I'm going to give you a chance at sentencing to tell me all of the reasons why things happened. At the plea, I just need a small amount of information from you. So let me be specific. Sure. Did you go into the Walmart store when it was open to the public?
Yes, I did.
And that was on September 21st, right?
Yes, I did.
Did you steal property? Did you take without paying for certain property of the store?
Yes, I did, sir.
What were the items that you took without paying for?
A baby seat. I saw a baby seat, a backpack, and I think there was, from what I recall, there was a blanket and something else, nail clippers or something, and a backpack. Did I say that?
All right.
And I think that was it.
And all of that stuff, did it add up to a value of more than $200?
Probably, yeah. Yeah.
All right. Any other factual basis questions that either of the council have?
No, Judge.
No, Your Honor.
All right. And again, I find that Ms. Brink has given me a proper factual basis. She's admitted to stealing property of the store from Walmart that was open while Walmart was open, and the value was more than $200. Are either council aware of any other promises, threats, or inducements not stated on the record?
No, Your Honor.
No, Your Honor. The court has complied with court rule.
All right. I will accept then the pleas as to all three of the charges. I do find them to be knowingly, intelligently, and voluntarily done, as she has properly answered my questions about promises, threats, or other inducements. Let me just make some notes. All right, Mr. Fortier, do we need to get some information from Walmart and give them an opportunity to be here for sentencing, or can we proceed today?
We can proceed today.
Mr. Brown, do you wish to proceed today?
Yes, Judge.
All right, Ms. Brink, what I'm going to do is I'm going to ask each of the lawyers what they think we should do for sentencing. And then I'm going to, after you've heard what they say, I'm going to give you a chance to tell me anything that you want me to know as well. So listen carefully. Mr. Fortier, your thoughts on sentencing?
Judge, after having an opportunity to review the video for this one, I think it was pretty clear there were some outside factors going on with Miss Brink. Frankly, I think the court's well aware of kind of what's been going on with her history. I think an appropriate sentence would be giving her some jail time with credit for what she's already served, but then putting her on probation. I would leave up to the court. If she is going to be on probation, I would ask that she continue any sort of mental health treatment that she is undergoing or should be undergoing. I think CMH, if they're not already involved, should become involved. And to that extent, whatever treatment recommendations she has, I think she needs to follow through with. There is no restitution as well, as all items were recovered. And I had an opportunity to talk with both police officers that were involved, and they understand that there were additional factors outside of just what most people might think is going on. So they were okay with the attempts.
Mr. Brown, allocution?
Thank you, Your Honor. I would largely echo what Mr. Fortier said. I am not going to rehash her history on the record. The court is very well aware of it. All I'm going to do is ask the court to fashion a sentence which primarily deals with her mental health, which is, I think, what should be the focus. Obviously, there is an element of punishment. She has been sitting for quite a while, but I want her to get the help that she needs. Thank you.
All right. Ms. Brink, this is your opportunity to tell me anything that you want me to know about you and about what you think the sentence should be. So if you have any comments, this is now the time to make them.
Good. Mostly, I just want you to know that I did relapse and drink a beer after being sober for about almost a year now. And so that negatively affected me. I spent an entire day trying to sober up. I had not taken my medication that day. Sometimes I'm usually pretty good about it, but I don't know what happened. I'm homeless and I've been living in my vehicle. It's very lonely being homeless. And I've got mental health problems, and so I don't always 100% understand what's going on, to be honest. So I just want the court to understand those things, and I appreciate Mr. Fortier being so kind with his words about about what you think I should be sentenced to. Larry Brown did a great job, in my opinion, representing me. And I'm embarrassed mostly, and so it's even hard to even verbalize how I feel right now and what I want you to know. And I'm ashamed of myself because I didn't think I would, after prison, I didn't think I would end up in this position again. And so I feel horrible, and I fucked up. Excuse my language, but that's the truth of it. And my parents are ashamed of me and embarrassed of me. And so that's enough punishment for me, to be honest. But I know you have to impose a sentence. And so if you can just give me work camp or probation or something minor, I don't know, because even if they let me out of jail, I don't know where I'm going to stay yet. So just take those things into consideration, I guess, if you can.
All right. Well, Ms. Brink, I want to say thank you for the work that you've done to get yourself back together with your mental health treatment. There's a world of difference between today and some of the previous conversations that we've had And I want to say you're doing much better today, and I appreciate that. You're a thoughtful person today, and
Thank you.
I think that bodes well for if you stay on your medication and stay on your treatment plan, things can go much better for you. But
Yes,
that's
sir. They,
kind of where,
you know, when I was in prison and even slightly before that, I wasn't working with CMH right away, but they messed with my meds a lot, and it got me all kinds of confused because they would change it a lot. While I was in prison, they changed my medications a lot. I had some seizures. I hit my head a couple times. But when I got out of prison, since then working with CMH, they've changed my medication so much, and so it's very hard to understand what's happened from then until now,
okay.
without getting outside view, outside, you know,
Yep.
person's opinions, because or facts even, really, because I know I've been in the hospital a lot. I can tell you that, and been in jail a lot, but like I don't like they just change it, you know, and so the shot of Abilify works pretty good. And so does the Zoloft and gabapentin. I need to get back on metoprolol for my AFib. I know that, and the gel's working with me on that too, so that's good.
Okay.
But
Well, I'm just simply going to say that the doctors are the ones that control all that kind of stuff. They're the
Right,
ones that,
right,
and
right.
sometimes they have to experiment and see what works best for you. But I'm going to require you to do that, to work with them. So
Yes.
let me ask you just one other small question before I tell you what the sentence
Sure.
is going to be. How much time have you been in jail now, up to this point?
I believe a month. Monday will make a month.
All right, so at least 25 days.
Yes, sir.
All
I
right.
believe so. Anyway, today's. I don't even know the day of the week. Thursday, I think. Today's.
Yes, today is Friday.
So, today's Friday.
Today's
Okay.
Friday
So,
the 17th. Have you been in jail for all of October and part of
yes.
September? All right.
Yes, sir.
Okay.
So since the 22nd of September, I've been in jail.
All right. I'm going to put you on probation for 6 months, just so we can make sure that you're doing what you're supposed to be doing with your medications and with your treatment.
Right. Yeah.
There's a cost for that. There's a $75 mandatory crime victim rights fee, a $50 justice assessment. I'm going to reduce I got 3 charges I got to do things on, so bear with me for just a
Right.
minute.
Yes, sir.
I'm going to reduce the court costs to $100 on each one of them. And I'm going to reduce the fine to $50 on each one of them. And then there's a $180 probation oversight fee on each one of them as well. So let me add up those amounts. That's a total of $770, and you can pay that over the course of probation.
Okay. Over the course of 6 months, then.
Yep.
Okay. Thank you.
I'm going to let you do community service work if you can't find work right away, so that you can work that off at the discretion of the probation office. There are some fines that you have to pay yourself, but you can enroll in some of them. I'm going to require you to go to CMH, Community Mental Health, and follow all recommendations and submit a release to probation so that they can know what you're supposed to be doing with community mental health and what your treatment program is. All right?
Yes, sir.
So take all your medications, go to counseling, whatever they tell you to do, that's what you're going to have to do.
Right.
No consumption of alcohol or non-prescribed drugs That means if your doctor tells you to take a drug, then you take it, but you can't take street drugs and you can't abuse your prescriptions. You understand what I mean by
Right.
that?
Yes, sir. Yes, sir.
I don't want you to go to any bars or places where alcohol is served by the glass. So stay out of
No.
there. That way, because if you're mixing your medications with alcohol, bad things happen.
Yes, I know. Yes, I know.
All right. I am going to send you, because you're not working right now, I am going to send you to the work camp for 10 days so that you can give back to the community. That'll make you feel a little bit better about yourself too once you get out and you're able to do something. And hopefully that'll give you a little bit of structure so that you know where you're supposed to be and when you're supposed to be there.
Okay.
Mr. Fortier, are you aware whether or not the United Way still deals with people that have housing issues?
I do not know.
Mr. Brown, are you aware of any other agency in the community that deals with housing issues that could help her find some place to land?
Unfortunately, no. I don't know if NEMSCA deals with those things or not.
There used to be an agency called First Call for Help that had a way of doing the phone tree and calling places like that. I'm going to ask probation to contact community mental health and help her deal with the homeless issue, or at least make some referrals. See what is out there.
Because I don't know where I'm going to live, is it okay if I ask when I'm getting out of jail? Like, is that happening today? Because I'm a little bit nervous about that. I have nowhere to go. Should I just try United Way when I get out to see if they'll put me up somewhere or something?
Yeah, I'm gonna ask our probation department if they know of any other community resource that deals with homelessness. I don't know that we have a specific shelter in town anymore. We used to, but I don't think we have one now. But I believe that DHHS may have some funding available for emergency bases.
Okay.
And I'll ask our probation department to call and see if there's anything that they can point you to when you are released. I'm going to give you 25 days in jail, credit for 25 days.
Great.
So you don't
Thank you,
have to
sir.
serve, you don't have to serve any additional jail time, but you will have to go to the work camp. And so you're going to need to contact them to get that set up and get started with that once you are released. And I'm going to ask probation to try to see if there's any place that we can put you, or that at least you can go and make an application for a place to stay. I can't guarantee anything, but we'll at least work with you and try to help you that way. Are there any other questions that you have, Ms. Brink?
No, sir. That is all.
Mr. Brown?
No, Your Honor. Thank you.
Mr. Fortier?
No, Judge.
All right. Good luck to you, ma'am. Please, for everybody's sake, stay on your medication and do your counseling like you're supposed to, okay?
Yes, sir, I will.
All right. Good luck
Thank
to
you
you.
so much. Yes, thank you.
Are you Chelsea Brink? I have to hear from you, ma'am.
Yeah.
All right. Thank you. I'm Judge Hesselink. I'm coming to you from the district court. You're here today because of an arraignment. And there's actually two files, a new file and a probation file. Let me call those cases. First one is the State of Michigan versus Chelsea Brink, file 25-44174-FY-3. That is set for a new arraignment. And we're also here today on the State of Michigan versus Chelsea Brink, file 25-44051-F3. That's a probation violation file. Let me turn to the first new file. With me today to assist in that is Richard Trush, defense counsel, and Mr. Fortier from the prosecutor's office. The new charge against you reads as follows. It says that on or about November the 18th of 2025 in the city of Gaylord, Otsego County, in count one, you did commit the offense known as Police officer assault, resisting, or obstructing. It says that you did assault, batter, wound, resist, obstruct, oppose, or endanger Colton Huff, a police officer of the Gaylord City Police Department, who you knew or had reason to know was performing his or her duties contrary to the Michigan compiled laws. That is would normally be a felony offense with a 2-year and or $2,000 fine. However, you've also been charged as a habitual offender, fourth offense notice, which has the effect of enhancing the sentence. That notice says that you were previously convicted of 3 or more felonies or attempt to commit felonies. In that on or about October the 13th of 2020, you were convicted of the offense of police officer assaulting, resisting, or obstructing in the 46th Circuit Court for Otsego County in the state of Michigan. On February the 5th of 2019, you were convicted of the offense of attempted arson, preparation to burn in the 46th Circuit Court for Otsego County in the state of Michigan. And on or about February the 8th of 2018, you were convicted of the offense of felony kidnapping, custodial interference in the 46th Circuit Court for Otsego County in the state of Michigan. Therefore, there is an enhanced penalty, and because the underlying offense has a penalty of less than 5 years, the new penalty would be up to 15 years in prison. Do you understand the name of count 1 to be police officer assaulting, resisting, and obstructing?
Yeah.
Do you understand the maximum penalty under the habitual fourth offense notice for that charge is now up to 15 years in prison?
Yeah.
I'm sorry, I have to hear something from you, either yes or no,
yeah.
ma'am. I'm sorry, I was not able to hear you. Thank you for making it a little bit louder. Count 2 reads as follows. It's entitled police officer assaulting, resisting, or obstructing. It says that on that same date and time that you did assault, batter, wound, resist, obstruct, oppose, or endanger Jacob Depew, a police officer of the Gaylord City Police Department, who you knew or had reason to know was performing his or her duties contrary to the Michigan compiled laws. Again, that would normally be a felony offense of 2 years and or $2,000 fine. However, you have also been charged with the habitual offender fourth offense notice that I just read to you on as to count 1. That now applies to count 2 to make that a felony offense with a maximum possible penalty of 15 years in prison. Do you understand the name of count 2?
Yeah.
Do you understand the maximum penalty for count 2?
Yeah.
All right. Count 3 is the name of that offense is Mail and Mail Depository Protection Act, also involving mail theft. It says that on that same date, time, and place that you did take, hold, conceal, or destroy mail addressed to another person, that is Lisa's Tavern, with the intent to deprive that person to whom the mail was addressed of the mail, contrary to the Michigan compiled laws. That is a misdemeanor offense. It has a maximum penalty of 1 year and or a $500 fine. Do you understand the name of count 3?
Yeah.
Do you understand the maximum penalty for count 3?
Yeah.
The final count 4, reads as follows. It says that on that same date, time, and place that you did commit the offense known as trespass, in that you did remain without lawful authority to remain on the lands or premises of Lisa's Tavern after being notified to depart therefrom by Elizabeth Arndt, who was the agent of the occupant of the lands or premises, contrary to the Michigan compiled laws. That is a misdemeanor offense. It has a maximum penalty of 30 days and or a $250 fine. You understand the name of count 4?
What is it?
It's called trespass.
Oh, yeah.
You understand the maximum penalty of 30 days and or up to $250 fine?
Yeah.
All right. You have certain rights, and I want to make sure that you understand those rights so you can decide what to do with them in the future. Your basic rights are you have the right to plead guilty, not guilty, or to stand mute. You have the right to have an attorney represent you, and you have the right to have a trial by a judge or a jury. At that trial, you would also have trial rights, which include the right to see, hear, and question all the witnesses against you, the right to present your own witnesses and evidence and get an order from the court called a subpoena to require those witnesses to appear and testify. At trial, you could also testify, or you could remain silent, and if you chose to remain silent, that silence could not be used against you. At trial, you'd also be presumed innocent until proven guilty beyond a reasonable doubt, and that burden of proof would remain with the prosecutor at all times. Finally, at a trial, you'd have the right to appeal any error at that trial. However, if you enter a plea in the future, you'd be limited to asking the court for permission to appeal, and that might not be granted. Do you have any questions about any of those rights?
No.
You believe that you understand those rights?
Yes.
All right. Mr. Trush, as to her right to an attorney, have you had a chance to speak with her about that?
I did, Your Honor. She has been screened and qualifies for counsel. Again, traditionally, I think she's been represented by Mr. Brown. I expect he'll be appointed in this matter as well.
All right. Ms. Brink, until you have a chance to speak, with your attorney, I'm going to enter a not guilty plea on your behalf in order to protect your rights. Because you've been charged with felony offenses, I'm also going to set some quick court dates to also protect your rights. The first date is called a probable cause conference. That'll happen in the next 7 days. That's a chance for your lawyer and the prosecutor to speak to see if they can resolve the case quickly. In addition to that, within the next 21 days, we'll set a preliminary examination date. Now, that's a short hearing in district court in front of me as the judge to determine whether or not the prosecutor can show a small amount of evidence called probable cause that you've committed the crimes that you've been charged with. That is not a determination of guilt or innocence. It is simply a check to make sure that there's sufficient evidence to proceed with the case. Do you have any questions about those 2 court hearings?
No.
All right. What we're going to do next is address the issue of bond. So I'm going to listen to both of the attorneys, and then I'm also going to give you an opportunity to tell me what it is that you want me to know before we make that decision. Mr. Fortier, as to bond.
Your Honor, I did submit a bond recommendation form. In it, I want to note that she is on probation currently in case 2544051-FY, where she was sentenced to 6 months probation on a retail fraud 2nd degree and 2 counts of attempted resisting and obstructing a police officer. She was sentenced on October 17th, 2025, so just about a little over a month ago. I think based on the fact that she was out on probation for an assaultive offense, she's got assaultive offenses in her criminal history. She does present as a risk to the community at large. The court's obviously well aware of issues that Ms. Brink has. She's continuously picking up trespassing and R&O charges when the police are called. So based on that, I think a bond amount of $10,000 cash or surety would be adequate. I would also ask that, in addition to the standard conditions of bond, that the court order no drugs or alcohol be consumed, along with no marijuana, and that she participate in a substance abuse testing or monitoring program at the discretion of community corrections. Ask that she would report via community corrections, and that she participate in a specified treatment program, specifically with community mental health. I know she had indicated prior circumstances that she was involved with them. However, I'm not sure the extent of that involvement right now. I think it needs to continue, or at least be essentially restarted if it's not happening. I would also ask that she have no contact with Lisa's Tavern, that she not re-enter Lisa's Tavern, and that because she is charged with an assaultive crime, on top of the fact that she's got felony criminal history, that she not possess any weapons or firearms. And that's it.
All right. Mr. Trush, your thoughts?
Thank you, Your Honor. In regards to bond on this matter, a few things that I think are important. Given the circumstances, we expect some amount of cash bond is going to be put in place here. I would indicate Ms. Brink has substantial connections to the community. She's essentially lived her entire life in Otsego County. I think the court is familiar with some of her economic circumstances. She reports that she's homeless. I know that she has reported that to the court consistently, I think, in other hearings, which I wasn't a party to, but happened to be present and observe. She reports that she struggled to get a job since being released from prison, with a felony on her record. She reports that it's disqualified her from a lot of jobs. She reports that she's always appeared. And again, I would just indicate to the court, I think that some cash bond is surely going to be put in place here. $10,000 seems high. I would suggest to the court a $5,000 bond is more appropriate. And I would suggest to the court, again, the court I think is aware of some of her other economic issues. And frankly, the fact that she has some other matters, which frankly, if she had available funds, I think would be more appropriately put to those than to a bond here. Thank you.
Ms. Brink, you do have the right to address me as to anything that you think would be important for bond. I would simply caution you that not to make any statements about the underlying facts of the case because we are recording this and it could be used against you later. But if there's anything that you want me to be aware of, I'd be happy to listen to that now.
I'll stand mute.
All right, thank you. All right, I do note, as the prosecutor indicated, that Ms. Brink has just recently been sentenced on a case that involved, at least in part, resisting and obstructing or attempted resisting and obstructing police officers, the same offenses that she's now alleged to have committed on this particular case. She was on probation at the time she was alleged to have committed these charges. That she has ties to the community, but she has indicated to me in not only that previous sentencing, but in the other cases that she's been involved with the court, that she is homeless. I believe that she sold her home that she had here in Otsego County a couple of years ago and used that money basically to stay in hotels for a little less than a year. She has not, to the best of my knowledge, had any long-time employment, if any employment at all, in the last year or so. So while she is well known to the court system, she has very limited things that tie her to this community other than the fact that she may have people that she knows in the area. So because of her inability to keep herself out of trouble and the fact that she is being violent towards our police officers, I believe that a cash bond of $10,000 cash and surety is appropriate in this case. Conditions of release on that bond include personally appearing for all court dates set by the court, abiding by any judgment of the court, not leaving the state of Michigan without prior permission of the court, not committing any crime while on release, and immediately notifying the court in writing of any change of address or telephone number. She must also not use alcohol, marijuana, or any illegal controlled substances while out on bond. She must participate in a substance abuse testing or monitoring program through community corrections. She must participate in a specified treatment program for any physical or mental condition, including substance abuse, and that was specifically would be community mental health, and follow all recommendations of that assessment. She may not, because of her danger to the others in the community, she may not purchase or possess a firearm or other dangerous weapon while out on bond. She may not have any contact with, direct or indirect, with Lisa's Tavern. That means she may not call it, she may not show up in person, she may not use the internet or social media. No contact means no contact. Finally, she may not enter Lisa's Tavern in Gaylord as well. And then upon her release, she must contact community corrections within 24 hours of her release so that they may monitor her while she's on bond. Ms. Brink, do you have any questions about those bond conditions?
No.
Mr. Trush, anything?
No, Your Honor, thank you.
Mr. Fortier, anything else?
No, Your Honor.
All right, Ms. Brink, we also have one additional matter. Before I forget, Deputy, could you make sure that Ms. Brink gets fingerprinted on this new charges as well?
Yes, Your Honor.
Thank you very much. All right, Ms. Brink, we also have a probation violation issue. The allegations made against you on that is that you were charged with a new criminal offense of larceny, resisting, obstructing, and aggravated assault on 11/18 of 2025. That's the charges that I just read to you. I'm not sure if that's exactly the way it should be read, but you've also been charged with police officer resisting and obstructing, and trespassing, and mail theft. The recommendation is that you serve 93 days in jail and that you be discharged from probation with fines and costs preserved. Do you understand the nature of the allegation made against you?
Yeah.
Do you understand the recommendation as to what would happen if you were to admit or be found guilty of that?
Yeah.
All right. I'm going to assume that you wish to have an attorney represent you on that matter as well. Is that correct?
Yeah.
All right. And I will, because I've just heard that you have qualified for court-appointed counsel, I will appoint court-appointed counsel or send that to Mr. Gilo to determine who should be your lawyer in that. I'm going to enter a not guilty plea on your behalf until you have an opportunity to speak with your lawyer about that. And then we're going to set a court date in conjunction with your new felony offense so that they're both heard at the same time. I don't know what that date's going to be yet, but we'll have that done for you. And we'll send the notice to you at the jail or at the address that you give us as to where you want mail sent to. Where would you like to have notices and mail sent to, Ms. Brink?
I'm in jail. What do you mean?
If you get out, obviously, if you're in jail,
I'm not
we'll
gonna
send it
get
to you
out.
there.
I'm homeless. I have no job and I'm homeless. I'm not getting out.
All right. Does that mean that you don't want to have a mailing address to where you can pick it up from
Right.
somebody else?
Right. I got no mailing address.
All right. So we'll send the notice to you at the jail. Do you have any questions about that?
No.
All right. That's all for today then. Thank you very much. You're free to go.
Anyone else, Your Honor?
I believe that's it for today. Thank you very much.
Good afternoon.